Your request for coverage is denied. Most seniors stop right here. They read those words, fold the letter, and put it away. The television stays off. The medication goes unpurchased. The procedure never happens. The case is closed before it opens. But this letter is not a wall. It is a ticket. Inside every denial, there is a building. More than a metaphor, a real administrative structure. A real administrative structure with 5 floors of review, each one designed to question what the plan decided, each one required by federal regulation, and each one almost entirely empty. Most seniors never ride the appeal elevator. They never know it exists. This is a case file. The evidence is the letter in your hand. The building has an address. The elevator has buttons. And the first question is not whether you can win. The first question is whether you will step through the door. The building stands inside every denial letter from a Medicare Advantage plan. It was constructed by the Centers for Medicare and Medicaid Services, the agency called CMS. They built it into Title 42 of the Code of Federal Regulations, Part 42.2, Subpart M bureaucratic coordinates. But inside those numbers, a floor plan, 5 levels. Level 1, plan reconsideration. The insurance plan reviews its own decision. Level 2, independent review entity. An outside contractor examines the file. Level 3, Office of Medicare Hearings and Appeals. An administrative law judge hears the case. Level 4, Medicare Appeals Council. A panel reviews the judge's decision. Level 5, Federal District Court. The judiciary opens its doors. 5 floors. And yet, when investigators look at the data, the elevator shaft is silent. The lobby has a lie in the upper floors of dust. One major analysis found that fewer than 1 in 100 denials ever reaches even the first appeal. Another report from the Health and Human Services Office of Inspector General documented that many beneficiaries do not know they can challenge a denial at all. The door is unlocked, the sign is posted, but nobody walks through. Why? Because the letter looks like a verdict. It reads like a sentence handed down. The language is bureaucratic, dense, legal. It uses phrases like organization determination and adverse coverage decision. It lists appeal rights in small print on the back of the page. It feels like bad news. And bad news you put away. But that is the first misconception. The letter is not a verdict. It is an instruction manual. The plan is required by law to tell you exactly how to push back. They must include the deadline, the address, the form, and the phone number. All of it is printed on the very paper that says no. Let's examine the evidence. The document itself, an organization determination. That is what CMS calls the initial decision letter. It states what was requested, what the plan decided, and why. The why is critical. The plan must list the specific rule, guideline, or medical policy it used to deny you. That language is not just disclosure, it is a diagnostic tool. It tells you where to aim your appeal. The clock starts on the date printed on the letter. For a standard service, you have 60 days to file a reconsideration request. 60 calendar days. If your health requires faster action, you can request an expedited review. The plan must decide within 72 hours. If you have already received the service and are appealing a payment denial, the timelines shift. The deadlines are different. But they are all in the letter. Most people never read this far. They see the denial and they shut down. The letter goes into a drawer. The window closes. The lobby empties. And so the first floor sits unused. Floor 1, plan reconsideration. You file a written request. You ask the plan to look at its own decision again. You can include new evidence, a letter from your doctor, medical records, a statement explaining why the service is medically necessary. The plan assigns a different reviewer, someone not involved in the original denial. That is the regulation. In practice, the reviewer works for the same company, the same building. the same employer. The plan has up to 30 standard days to decide. For expedited requests, 72 hours. For payment reviews, 60 days. The overturn rate at this stage is low. CMS reports show that plans sustain most of their own decisions upon reconsideration. The internal reviewer confirms what the first reviewer concluded. The door you open leads to a hallway that circles back. The first floor confirms the lobby, but you did not climb one floor to stop. The second floor is where the outside referee enters, and this is where the pattern shifts. Level 2. Independent Review Entity. The IRE. When the plan denies your reconsideration, you have the right to escalate within 60 days of that adverse decision. The case file leaves the insurance company. It arrives at an office that does not bill the plan, does not report to the plan, and does not care about the plan's prior authorization software. Right now, the primary IRE contractor is Maximus Federal Services, a company hired by CMS, not by the insurance carrier. You may never see the building. You may never meet the reviewers. But your file sits on their desk and they read it fresh. This is where the numbers shift. Studies of the appeals process show that the independent review entity overturns a significantly higher percentage of denials than the plan's internal reconsideration. Some data points suggest a significantly higher percentage reversal at this stage. The precise figure fluctuates by year and by service type, but the direction is consistent. An outside set of eyes sees what the first reviewer missed, or it sees what the first reviewer was instructed not to see. The IRE is not a rubber stamp. It is a clinical review conducted by professionals who apply Medicare coverage rules, not the plan's internal guidelines. The evidence you submitted at level 1 gets a second look. If your doctor wrote a letter explaining why an alternative treatment is not appropriate, that letter now lands in front of someone paid to be impartial. Yet the volume of cases reaching the IRE is a fraction of the reconsideration filings, and the reconsideration filings themselves are a fraction of the denials. The elevator empties with every floor. Why? Fear. Complexity. The assumption that if the plan said no twice, the answer must be final. The exhaustion of being sick while fighting paperwork. The calendar. The phone calls. The sense that no one is listening. But the second floor exists as a structural check, and the third floor exists because CMS built a backstop against even the IRE. Level 3. Office of Medicare Hearings and Appeals. OMA. An administrative law judge, an ALJ, reviews the case. This is not a courtroom with wooden benches and a jury. It is a hearing room. It can happen by telephone or video conference. There is no judge's robe in most cases, but there is a judge's authority. The ALJ is an employee of the federal government, independent of the plan and CMS. You can present evidence, you can have witnesses, you can explain, in your own words, why the service should have been covered. You do not need a lawyer, though you are allowed to bring one. The hearing is recorded. The decision is legally binding on the plan unless CMS or a court overturns it. There is a dollar threshold. As of current rules, the amount in controversy must meet a minimum to access the hearing. For most service denials, that threshold is roughly $180, a small number intentionally. It keeps the door open for everyday claims, but the barrier is not the money. It is the psychological leap from filing papers to appearing before a judge. The hearing calendar is open slots. The administrative law judges are there. The hearing office is staffed. And OMACH's own data shows the caseload is lower than the pipeline below it would predict. Those who win at the IRE need no hearing. But among those who lose at the IRE, only a tiny number request one. The third floor is practically vacant. It is hard to understand why. The evidence suggests that when beneficiaries reach the LJ, their odds improve again. The judge is not bound by the plan's clinical criteria. The judge applies Medicare law. The judge asks the plan to justify its denial on the record, and often the plan's justification looks thinner under direct questioning than it did in a form letter. But to stand in front of a judge, you must first believe you belong there. Most seniors believe the opposite. The system trained them to accept a first no. The letter trained them. The phone hold music trained them. The exhaustion trained them. They did not know there was a fourth floor, level 4. Medicare Appeals Council. The council sits inside the Department of Health and Human Services. A panel of attorneys and analysts reviews the ALJ's decision. You must request review within 60 days of the judge's ruling. The council looks for legal error, procedural mistake, or abuse of discretion. It is not a second trial, it is a quality check. The council is a gatekeeper, but it is also an exhaustion requirement. Before you can step into a federal courtroom, you must go through the council. The rule exists to keep Medicare disputes inside the administrative system for as long as possible. The council's review is paper-based. You can file a written argument. The plan can respond. Few cases change here. The council tends to defer to the ALJ's factual findings unless something clearly went wrong. But the council's decision is necessary. It is the final administrative word. You have now climbed 4 floors. The plan said no. The plan said no again. An independent reviewer may have said yes or no. A judge may have ruled. A council panel may have reviewed. If you're still standing, still denied, and the dollar threshold is met, 1-4 remains. Level 5, Federal District Court. Judicial Review. This is not a Medicare building anymore. This is the federal judiciary. You must file a complaint in the United States District Court. You will need a lawyer. The court does not appoint counsel for these cases. The government will be represented by the United States Attorney's Office. The plan's lawyers will appear. The stakes are formal, the cost real, and the timeline measured in months, not days. The amount in controversy must meet a higher threshold, currently around $1,800 for most claims. The case must present a genuine question of law under the Medicare Act. The court can affirm, reverse, or remand the case back to CMS. The judge wears a black robe. The courtroom is cold. The record is public. Almost no one gets here. The number of federal court Medicare Advantage appeals each year is minuscule. Dozens, possibly fewer. It is the top floor of a skyline you can barely see from the ground, but it exists, and its existence is the point. The building has a roof. The system was designed to not be a dead end. Every denial has a path upward, no matter how long, no matter how quiet the elevator becomes. Now return to the lobby. The letter. Your name. The plan's logo. The words adverse determination in bold. You are holding the only key you need. The letter is not a rejection. It is a map. The appeal rights section tells you where to write, how fast you must act, and what language to use. The deadlines are on the page. The address is on the page. The phone number is on the page. The plan is legally required to give you everything you need to begin. What do? Tomorrow morning, you open the letter again. You find a date. You count the days left. You write a short statement. I'm requesting a reconsideration of the denial dated. Enclosed, please find a letter from my treating physician. You sign it. You make a copy. You send it by certified mail. You have stepped into the lobby. You have rung for the elevator. It comes. The first floor is a re-examination. The second floor is an outside set of eyes. The third floor is a hearing. The fourth floor is a legal review. The fifth floor is a courtroom. Most of these floors will never see your case. Most will not need to. But the path exists. The data on overturn rates tell us something that should reframe how you see the denial. Not every claim is winnable. Not every denial is wrong. But a meaningful percentage of denials that are challenged eventually yield to the appeal process. The government's own auditors have found that many prior authorization denials in Medicare Advantage were inappropriate under Medicare rules. When plans are forced to justify those denials at independent levels, the denials break. The letter was not a verdict, it was the lobby. Medicare said no, and that is not the end. It is the start of a process with 5 floors, a federal mandate, and an instruction manual already in your hand. The building is open. The elevator is waiting. The only question left is whether you will ride it.